Good afternoon and welcome to the Law&Crime Trial Network. I'm your host, Brian Buckmire. Now, if you're just catching up with us, we are currently watching the Rosenbaum case. Now, there's some legal arguments being made there as to whether or not the transcript should be brought into evidence, and therefore whether or not the jury can evaluate that transcript after the evidence has all been presented. We will come back to that case when we have some live action for you. But this morning we did get a verdict in the Hassel case, and that was a verdict of guilty. Let's take a look at that verdict being read. So there you see Hassel being convicted of the murder. Obviously, she's not being sentenced as yet. We will bring that to you when we get a chance. I am obviously joined here by Michael Koribanics, and we're here discussing the case. Mike, how you doing?
Good. How are you today?
Good. It's always good to have a little Buckmire Koribanics on Thursday afternoon, right? All right, so with this Hassel case, this was the love triangle where the co-defendant was charged with actually murdering, and this is the girlfriend who's charged with killing her husband, or wife, sorry, charged with killing her husband. This is an aiding and abetting case, right? I know the defense attorney was saying she wasn't the one who pulled the trigger, but that's not enough to defend yourself from this, right?
That's a layperson's understanding of aiding and abetting, and everybody always speaks about they weren't the trigger man, but under the law, if you're the person who's involved and you're a co-conspirator, you have an agreement with someone, it doesn't make a difference. You're just as guilty as being a co-conspirator because you have an agreement. There's a meeting of the minds to perform that criminal act.
Yeah, I mean, even my grandfather, he was a farmer, and he used to tell us as young kids and even as children, he'd always ask, like, who's the guilty person? The person who lights the house on fire or the person who watches it burn? And it's kind of like that. Like, you didn't strike the match, but you might have given him a little gas or said, hey, go do it. And that's kind of it here. But I believe the crux of the case was actually the confession that was given during the interrogation. So I understand for the jury it was kind of cut and dry. She confesses to it, and therefore she must have done it. Obviously, the defense brought up the defense of what many of us call a false confession, where the stress or the situation of giving a confession overdoes someone's typical ability to tell the truth to the point that they will confess to anything. What I usually tell people is, think of a kid who's like, hey, the parent comes up and says, didn't you take this? And the kid might be just saying, I didn't do it, but the pressure gets to be so hard. And sometimes people confess to things just to say, hey, I just need to get this over and done with. Maybe if I told mom I took the cookie, it'll eventually come out that I didn't, but at least I can end this conversation. It appears that that's what the defense was going with here, but it never really stuck with the jury. Well,
it's always very difficult to override a confession. However, I think it's getting easier as people become more educated about the problems with false confessions. Central Park 5, perfect example. There's a technique, the Reed technique, which is really 9 steps that these officers, detectives are taught to really get a confession. It's controversial. A lot of people don't realize the fact that police officers are allowed to lie while they're trying to get a confession. And there's studies that are shown that some people will say anything once they're led along because nobody knows what it's like till you've sat in the hot seat and have been interrogated by a police officer in those surrounding circumstances. And when they're talking about a murder, your life's on the line. And people should be more counterintuitive and assert their Fifth Amendment right. That's why it's so important, your right to remain silent. They have to prove the case against you. Some people actually think they could talk their way out of it. But you're on a very dangerous fence when that occurs, Brian, because of the fact of you're telling the jury it was a false confession, but you're also telling the jury your client's a liar.
Yeah.
So it's difficult. Yeah. But I agree with you about experts.
Yeah. And that's not to say that this was or was not a false confession. Of course, the jury weighed the evidence and they saw what they saw or what they believed they saw. And this could very well have been a person unburdening themselves of the guilt of committing this act. But I think that I'm talking strictly about the analysis in which a defense attorney is trying to go for it. And I agree with you. Every time I talk to people who are laypersons said, oh, no, I would stick to my guns. I would do this. I would do that. I would always tell the truth. I wouldn't confess to something I didn't do. But the amount of pressure that can be given, you're right, it is legal for officers to lie. I mean, I'm sure you've heard of case law where it says that a confession is incorrectly given, where the officer says, hey, that baby is about to die, and we need to know how they were struck or how this happened or this person's about to die. The information or the confession you're about to give could save a life. And that alone has a person breaking down and be like, all right, what do you need me to tell you? I'll tell you whatever it is. Do you think that enough was done to convey, I mean, obviously not because he was convicted,
right.
But do you think enough was done to try to convey that this could have been a false confession?
I think those, if you're not putting an expert on, your cross-examination has to be devastating of the officers, because you're not able to put your client on to explain it away. So you really have to, that's one thing where you really have to attack the process, how the confession was taken. You really have to educate the jury as to, and I mean as simple as, what was the room like? Ladies and gentlemen, you see the room in the videotape. Put yourself in that room. There's no windows. There's you and an officer, someone you don't know, someone you've never been in front of, someone who's just intimidating by the mere status and authority they're presenting to you. You know, was the officer wearing a gun when he took the statement? Was his badge out? All these things, I think you really have to paint a picture, and it's very difficult and very tedious to do on a cross-examination.
Yeah, so the confession was only a small piece that we believe led to the conviction. Let's look at the more that led to this conviction. All right, so it took a little bit of research for me and especially some explanation from our producers. I guess I'm getting a little bit old. I turn 31 tomorrow. But Snapchats, from my understanding, they just went away once you got them. But she took an extra step and deleted the actual account, and therefore it made it that much harder for her to recover. So, I mean, Mike, one would think, I use Snapchat because once I take the photo, it's going to disappear, so it's good. It's built-in defense. You're never going to see it. But now it shows that she took an actual additional step past probably what us old guys would think about, because we're about the same age, right?
Right.
And now she's just completely wiping it. So doesn't that just show evidence of guilt even more so?
Well, anytime you touch any kind of evidence, but 25 years ago we were the same age. Anytime the prosecution has some sort of showing of a destruction of evidence by a defendant, it's really strong. It's really strong because it shows, and they will argue, a consciousness of guilt. And there's, in New Jersey, I know, and in the federal courts, you can ask for that instruction that the defendant's actions showed a consciousness of guilt. And how you establish that mainly is by showing the action, the date and time it took place, in the context of when the accusations for the criminal misdeed took place. And that's really strong.
Now, consciousness of guilt, as I understand it, and I've applied it in my cases, it's not the nail in the coffin that prosecutors love to think it is. I know many prosecutors think, hey, I showed consciousness of guilt. It must show evidence of the crime actually happening. But there's got to be some pushback from the defense attorney, either to say, hey, this can be interpreted more than one way, and here's a benign reason as to how it can be interpreted. But I mean, what other reason would you have for deleting your whole Snapchat account? Like this got to only show one thing, right?
Well, you know, it's interesting you said that, because you were talking earlier about the age difference of people and their understanding of technology. I mean, a guy like me on the jury is really going to be lost in all this Snapchat talk and all the technology. But also, like you said, there's always an alternate explanation of why people do things. I mean, I may delete my account on my phone on something and not know I deleted it. Mm-hmm. It could just be my ineptness at the technological age. And that's an argument you can make here. I don't know if it carries the day, but there is pushback, and I agree with you. Whenever consciousness of guilt comes, as a defense attorney, you've got to push back and give an alternative explanation if one exists.
Yeah, and I know many people who delete social media platforms in one way or another because they say, hey, I broke up with this person, so I don't want to have a connection with them at all. But you definitely do not want to delete your connection to the Law and Crime Trial Network after this break.